For many decades, the legal model and the attitudinal model were the main approaches that political scientists used to explain Supreme Court decisions. Just to illustrate it, the dissertation advisor of my dissertation advisor was Harold Spaeth, who is now a retired professor at Michigan State University. And Spaeth got his PhD in the 1950s and has been active ever since. And he can say things like, I've read all Supreme Court decisions and I can tell you the only thing that matters is ideology. So that was a fairly common view among a group of political scientists who studied the courts for a long time. Now, during the last 2 or 3 decades, different approaches have come up and have become more important in political science. And those approaches look at factors outside the Supreme Court that go beyond simply the law or the ideologies of Supreme Court justices to explain Supreme Court decision-making. In this brief summary, we look at 5 types of outside influences, several of which are closely connected. First, public opinion, then second, the executive branch, that is the President and the Department of Justice mainly. 3, Congress. 4, parties to the case, that's the parties involved in the dispute that the Supreme Court decides. And finally, amicus curiae, and I let you guess what this is. Let's start with public opinion. There are basically 3 ways in which public opinion can influence the Supreme Court. You see 2 here. Points 1 and 2 basically point to the fact that justices are elected by political actors who are in turn elected by the public. So because the president nominates or appoints justices and senators confirm justices, there is this indirect effect of public opinion because through the election the public influences who is going to select the justices. The second type of influence is related to the fact that justices interact with people and are influenced by public opinion and are actually part of public opinion. So justices are members of the public, they read the newspapers, they watch TV news, they interact with people, right? And particularly in Washington. Washington is a very politicized city, so just by living there, justices clearly are part of the public and cannot be isolated from public opinion. In addition, justices travel around the country, particularly in the summer, and give speeches. And there they also interact with people and hear what their opinions are, and if you do this, you cannot be immune from influence. One area, I think, where we can see how public opinion influences Supreme Court justices is the debate on same-sex marriage. Over the last years, or if you look at it like this, over the last decade and a half or 2 decades, we find that the Supreme Court has moved from a position where it was very tolerant of discrimination of same-sex relationships to a position where it actually declared a right to those relationships, and a position where more and more judges support the right of same-sex couples to marriage. And this goes together with the movement in public opinion. So I think we can make the case that public opinion may have influenced this. The third way in which public opinion can influence the Supreme Court and Supreme Court decisions is summarized in point 5. Sometimes there are legal concepts that are actually connected to public opinion. A famous example is the idea or the concept of cruel and unusual punishment, which is part of the 8th Amendment of the Constitution. And the deal here is that the public's sense of what's cruel and unusual changes over time. During the founding period, hangings were common and were not considered cruel and unusual. Now, death penalty by hanging is considered to be cruel and unusual. More recently, we've seen that the Supreme Court has decided that the execution of intellectually disabled people, the execution of people who committed crimes when they were minors, violates the prohibition of cruel and unusual punishments. And very explicitly, in those decisions, the court looked at how did public opinion change on this? What is the sense of the public now and of the political system as a whole about what is cruel and unusual punishment? The president has influence on the court in various ways. First, we already saw that the president appoints justices. Another influence that the president can take is a bit more indirect through the president's role as head of the executive branch. The president appoints, for example, the Attorney General, the head of the Department of Justice, also the Solicitor General, who is one of the top members of the Department of Justice. Several Solicitor Generals have become Supreme Court justices. Most recently, Justice Kagan was appointed to the Supreme Court just while she was still Solicitor General. Now, what does the Solicitor General do? The Solicitor General decides whether the federal government gets involved in a Supreme Court case, whether it appeals a case to the Supreme Court, and what arguments it's going to make at the Supreme Court level. And in fact, the Solicitor General has so much interaction with the Supreme Court that he or she actually has an office in the Supreme Court. The Solicitor General doesn't work on an everyday basis at the Supreme Court, but on days when he or she argues before the Supreme Court, he or she uses this office. Now, the Solicitor General is very influential on the Supreme Court in various ways. First of all, it can be shown that if the Solicitor General asks the Supreme Court to hear a case, the Supreme Court is much more likely to issue a writ of certiorari. So the Supreme Court is much more likely to hear a case involving the federal government. But in addition, the Solicitor General typically is a highly experienced lawyer and knows how to make arguments that the Supreme Court justices are receptive to. So the Solicitor General tends to be more successful before the Supreme Court because he or she knows how to make a good legal argument, and good legal arguments still make it easier for the Supreme Court to say, okay, here's a position that we can agree with, that we can justify in a Supreme Court decision. So in this sense, the Solicitor General's influence is a little bit through the legal model, by proposing good legal arguments that the Supreme Court can rely on. Another influence that the President can take is through his or her, well, so far his role as basically the head of the enforcement branch of government, the executive branch. The President is the commander-in-chief of the military. The President can nationalize the state militias, and the President oversees, in the end, the federal police, the FBI, etc. So, the Supreme Court, on the other hand, cannot enforce its decisions. The Supreme Court can just declare what the law is and who wins a court case. In the end, it has to rely on other actors to enforce the decision, and that's where the President has some influence. If the President doesn't show an interest in enforcing a decision, most likely not much will happen. If the President, on the other hand, decides to enforce, then the decision can actually make a difference. Here's a famous example. In 1957, President Eisenhower sent the 101st Airborne Division to Little Rock, Arkansas to help integrate Central High School there. And this was as a follow-up to the 1954-1955 Brown versus Board of Education decisions that declared racial segregation of public schools to be unconstitutional. Sadly, this type of enforcement was more the exception than the rule with respect to Brown versus Board of Education. And in fact, on the whole, Brown versus Board of Education didn't make much of a difference in terms of actual integration of public schools. What happened was that about 10 years after Brown versus Board of Education, Congress passed a series of laws, for example, the 1964 Civil Rights Act, that tied integration of public schools to federal funding, and then suddenly schools started to become desegregated. So this gets us to the next point actually. Congress has a variety of tools available that it can use to place pressure on the Supreme Court or to help the Supreme Court. So first of all, if the Supreme Court makes a decision that Congress doesn't like, Congress can do several things. First, it can pass a new law that contradicts the Supreme Court. Now that's particularly useful if the Supreme Court decision just interpreted a statute that Congress had passed before. So if Congress doesn't like this interpretation, it can simply pass a new statute that corrects the Supreme Court. This doesn't work that easily in cases in which the Supreme Court interpreted the Constitution, because the Constitution can only be changed by constitutional amendment. So if Congress doesn't like the decision of the Supreme Court interpreting the Constitution, it can try to propose a constitutional amendment. Honestly, that's a fairly weak tool that Congress has. We have seen already that the constitutional amendment process hasn't resulted in many constitutional amendments, but in extreme cases it has been used in the past. Now, on the other hand, as we already saw, Congress can pass laws that make it easier for Supreme Court rulings to have an impact, to implement the Supreme Court rulings, like the Civil Rights Acts that actually furthered the desegregation of public schools. So that's something that Congress can do if it likes the Supreme Court decision. Congress can also modify the court's jurisdiction, and that's something that Congress can do if it doesn't like what the Supreme Court does. That's actually something where it hinders the Supreme Court. It can simply say, all right, Supreme Court, now you cannot make any decisions in the following area of law. It doesn't happen very frequently, but it happened a couple of times after the Civil War, for example. Congress can also pass laws that change the Supreme Court in other ways. For example, Congress can change the size of the Supreme Court. The number of justices has changed over time, and Congress can add to the number of justices or decrease it. So that's another possibility. Finally, Congress can impeach justices. And that's something that has actually happened in the past. And the process is just as with presidential impeachments. A majority of the House has to bring charges of impeachment, and then 2/3 of the Senate have to convict. And if this happens, then the justice is removed from the court. Now, if you think about all of these ways in which Congress can do things that affect the Supreme Court, you can imagine that there are situations where the Supreme Court says, all right, we would like to make this decision in this particular case, but if we do this, we'll get a hard time from Congress, so maybe we want to do what Congress prefers and not what we prefer. The most famous example of this happening was Marbury versus Madison, an 1803 case that's famous because it provided a justification for the Supreme Court to have the power of judicial review, which is the power to basically declare that statutes, laws passed by a legislature, are unconstitutional and cannot be enforced anymore. So really in brief, what happened was that John Marshall, the Chief Justice of the Supreme Court, was a Federalist who had been until 1801 a member of the Federalist administration of John Adams. William Marbury was another appointee to the courts in DC by the Federalist government. He was a Federalist himself. James Madison was the incoming Secretary of State of the new government in 1801, which had been elected the year before, and that was the government controlled by the Jeffersonian Republican Party, which nowadays is known as the Democratic Party. And there was this very strong partisan rivalry between those two parties, and what happened was Marbury had been appointed as a Justice of the Peace but had not yet received his commission, basically his job contract, by the time James Madison took office, and Madison then refused to deliver the job contract or commission. And Marbury went to the Supreme Court and basically asked the Supreme Court to force Madison to deliver the commission. Now here is what Congress did to threaten the Supreme Court at that point. First of all, Congress repealed the 1801 Judiciary Act. That was a law that had reduced the number of Supreme Court justices, basically taking away President Jefferson's power to appoint Supreme Court justices. But it had also created new lower courts and appointed new judges for life. And by repealing the act, Congress basically took away those judgeships and made sure those judges, the new judges, would not take office. So that was a direct threat towards the independence of the federal judiciary. Also, Congress cancelled the 1802 Supreme Court term. I mentioned already that Congress can change the Supreme Court's jurisdiction. This is an extreme case. Congress basically said you cannot make any decisions in 1802. And finally, Congress impeached Justice Pickering just to show what its powers were. Pickering was not a particular successful and popular justice at this point. He was an alcoholic, and probably he had psychological problems as well. So he was kind of, I would say, a consensus candidate for impeachment. Nobody really thought that he was a good justice. But by impeaching him, the Congress basically flexed its muscles and showed the Supreme Court, look, this is what we can do if we don't like what you are doing. In other words, Marshall was in trouble. Marshall basically thought Marbury should have gotten his commission, and basically he was also supporting his Federalist Party fellow. But at the same time, if he ruled in favor of Marbury, Madison would not comply with the decision. Remember, the Supreme Court cannot enforce its own decisions easily. So John Marshall had to find a way to compromise in order to get something out of this case, and at the same time to placate Congress and the Jeffersonian administration. So here's what Marshall did. First, he sounded off. He wrote an opinion that said Marbury is right, he should get his commission, Madison is really wrong not delivering the commission. Then he gave something to the Jeffersonians. Basically he said, but I'm not able to help Marbury, sorry guys, the Supreme Court doesn't have the power to force Madison to deliver the commission. And then he took something for the Supreme Court again. He said, well, we don't have the power to force Madison to deliver the commission because the statute that gave us the power was unconstitutional. So basically, by doing so, Marshall clearly showed that the Supreme Court had the power, the authority to declare federal laws unconstitutional. So that's an example of basically striking a balance. Madison couldn't really do anything against this. He achieved his goal. He didn't want to deliver the commission, but at the same time the Supreme Court won a little bit as well. Two more external influences. First, or fourth to be precise, the parties to the case. The people actually involved in a dispute that goes to the Supreme Court and their lawyers. They're important because if they do not bring the case to the Supreme Court cannot make any decision. The Supreme Court cannot act on its own initiative. So that's very important already. In addition, if the parties to the case make good legal arguments, this makes it easier for the justices to choose between the two sides, because justices not only pursue their own political goals, but they also want to write legal opinions that are well argued and that establish the justices as good lawyers who can provide good legal reasoning and justifications. Finally, here are the amicus curiae. Now, what are those? Those are lawyers who are not involved in the case itself, but provide arguments as friends of the court. They're third parties, basically. Often they're lawyers hired by interest groups, sometimes even government agencies, sometimes the government itself. The Solicitor General frequently is an amicus in a case. Amicus curiae submit written briefs making legal arguments for one side or the other, but they also are often involved in oral arguments. And why are they influential? Well, if they provide good legal arguments for one side or the other, it makes it easier for the justices to justify a decision in favor of that side. Also, they can strengthen a side by showing that a case is important for society as a whole. For example, in some of the education affirmative action cases regarding the University of Michigan, the US military actually provided amicus brief saying we need diversity in education for the officers, because if we have mainly minority soldiers in the lower ranks, but then in the higher ranks we do not have minority leaders, we have a problem. So this indicated that there was a larger social importance of this issue and a particular side in that dispute. So you see that there are several outside influences that can influence Supreme Court decisions in different ways. Some of them influence the actual policy goals, the attitudes justices have. Think about public opinion. Some of them influence the environment in which the justices act. Think about the pressure Congress can exert, right? Justices try to strategically adapt to the situation they're dealing with. And then there are influences that affect the justices through legal argumentation. The justices say, okay, this is a good legal argument, I may want to make it or at least consider it when I make a decision in a particular case. Now, in terms of whether these types of influences always work, the evidence differs, but for all of those factors there is at least some evidence that they make a difference. Either we know individual cases like Marbury versus Madison where we can point to the influence, or there are actually studies that use statistics and other systematic analyses to show that yes, some of these factors actually make a systematic and regular difference in Supreme Court decision making.